The U.S. Supreme Court has struck down a key provision of the 1965 Voting Rights Act, a provision designed to help minorities elect representatives of their choosing. In a 6-3 ruling, the court ruled that a Democratic district in the state of Louisiana was drawn exactly along racial lines, favoring one group over another. The ruling could now allow Republican-led state governments to redraw many districts in ways that could favor their party in upcoming elections. Critics of today's ruling warned that it could make it harder for minority communities to have their voice represented in Congress.
Today's decision by this illegitimate Supreme Court majority strikes a blow against the Voting Rights Act and is designed to undermine the ability of communities of color all across this country to elect their candidate of choice. But we're not here to step back, we're here to fight back.
Yes.
Now, when this decision came out earlier today, it's an unacceptable decision, but not an unexpected decision. Because this isn't even really the Roberts Court. It's the Trump Court.
Well, strong words there from the U.S. House Minority Leader. I want to pull in now the History and African American Studies professor, Gerald Horne, from the University of Houston. Professor Horne specializes in the Civil Rights Movement and the Voting Rights Act. Professor, it's good to have you on this Thursday. We just heard Hakeem Jeffries there saying that this ruling is an affront to African Americans. What do you say?
Well, it's not only an affront to African Americans, it's an affront also to Spanish-speaking voters. Recall that the Voting Rights Act of 1965 authorized that ballots should be printed in the Spanish language, perhaps the language of the Chinese American community as well. It's also a blow to judicial interpretation. As Elena Kagan, the justice who wrote the scathing dissent in this decision, said, if there was a dispute about the Voting Rights Act, it should have been left to Congress to sort out that dispute. And Congress had sorted out that dispute. And the Supreme Court, acting as a super legislature, basically took the role of Congress, which is ironic because recall that during the 1960s, the right wing was oftentimes complaining that a liberal-leaning Supreme Court was acting as a super legislature. Now, the worm is turned, and the right-wing court is acting as a super legislature. I should also mention that this has implications for U.S. foreign policy. Recall that the state and issue is Louisiana. Recall as well that approximately 30 years ago, David Duke, a leader of the U.S. Nazi movement, and a leader of the Ku Klux Klan, which is an analog to the Nazi movement, won a majority of the so-called white vote in that gubernatorial election. It took a massive turnout from black voters to make sure that he did not ascend to the highest office in that particular state. And this decision opens the door for such right-wing shenanigans to take flight as we speak.
Well, Professor, I hear what you're saying. You're saying that another David Duke could now be possible because of today's Supreme Court decision. But for our viewers, briefly, if you could tell us what the Voting Rights Act of 1965, what it did, what it was.
Well, the Voting Rights Act of 1965 was a response to U.S. apartheid. Before 1965, fundamentally and effectively, most black voters in the South and states like Louisiana and Mississippi did not have the right to vote. The Voting Rights Act of 1965 was a kind of Magna Carta for black and minority voters. For example, in an overturned provision of the VRA, the Voting Rights Act of 1965, the right-wing Supreme Court said that if Louisiana or Mississippi wants to change certain kinds of regulations in their voting statutes, they have to go to Washington to get so-called pre-clearance. That is no longer the case. Now, with this decision in the last 24 hours, you have a further evisceration of the Voting Rights Act of 1965. And I would be remiss if I failed to acknowledge that our civil rights community made a fundamental error when they went along with provisions that led to the weakening of some of our most militant elements in our community, which strengthen the right wing, which has led directly to this decision.
Professor, it seems that since 1965 in the United States, voting district lines have been drawn on the assumption that race determines how a person votes. And that in itself sounds racist. We know that America has changed significantly since 1965. Is it possible that legislation from 70 years ago has served its purpose and could be in the wrong hands? Now, it could be doing more harm than good today.
Well, the fact remains that in Dixie, in places like Louisiana, 9 out of 10 Black voters tend to vote for the Democratic Party. Alternatively, 9 out of 10 voters who are defined as white tend to vote for the Republican Party. You can call that race. You can call it a legacy of history. You could call it sensitivity to oppression and persecution on the part of the Black voters. But in any case, that is the stunning reality that the Supreme Court seeks to ignore.
Okay. I know that it may be too late for voting districts to be withdrawn in time for the November midterms. What do you expect to happen in the next election in 2028?
Well, I would like to think that your question has relevance, but within minutes of this decision, the governor of Louisiana, Jeff Landry, went to the legislature and sought to change the rules for a primary election that takes place in 2 or 3 weeks. That is to say that this decision by Jeff Landry will be replicated throughout the South. There will be primary elections as late as August, for example.
Yeah.
So it's not incorrect to suggest that this may have impact on the November elections, and certainly will have elections. It will have impact on the elections in November 2028.
Professor Gerald Horne, we appreciate you taking the time to talk with us. We will definitely be following this story and following the redrawing of district lines. We appreciate your time tonight. Thank you.
Thank you.